Good evening, everyone, and welcome to the Lower Hudson Special Education Task Force Program, Codes of Conduct and Rights and Responsibilities of Students with Disabilities. My name is Julie Passman, and I co-chair this regional task force along with Jessica Bauman, who's here with us tonight. And we are joined by several of the task force executive council members, including Alyssa Galea, who you probably saw on your screen, and she's managing the Zoom for this evening. And Stephanie Shabin is also on our executive council, who's one of our panelists. Before we get started, I just need to share our notice of recording. This training will be recorded to ensure the information will be available to all who are interested. If you do not wish to have your image appear on the recording, please turn off your video. I think most people have been turned off already. If you do not wish your name to appear on the recording, please change your name by clicking the three dots, which are generally on the bottom of the screen, selecting Participants, hover over your name, select More, then rename to something that does not identify you. So for those of you who are not familiar with the Lower Hudson Special Education Task Force, we are the regional arm of the New York Special Education Task Force, which is run under the auspices of Disabilities Rights New York. The Lower Hudson Special Education Task Force seeks to bring together the full spectrum of stakeholders in special education in forums such as these to promote positive outcomes for students with disabilities. Tonight's program was initially crafted and scheduled for March 19th, 2020, which was the eve of the pandemic. And needless to say, things have changed since then. And given the current variety of learning models, in-person, hybrid, remote, school codes of conduct are being applied in new learning environments as well as the traditional learning environments. It is our hope that this program will encourage families and professionals to review school codes of conduct to better understand student rights and responsibilities and expectations for student behavior, and encourage communication and understanding among all stakeholders in special education. We are so fortunate to have an incredible panel with us. We have three highly knowledgeable and experienced panelists, Dr. Lisa Brady, Stephanie Burns, and Stephanie Shabin. Dr. Lisa Brady is a superintendent of the Dobbs Ferry Schools. As a public school administrator, Dr. Brady has shared her vision for schools that prepare teachers and students to embrace change with excitement and enthusiasm. She is widely known for her early adoption of technology and for supporting teachers to take risks with their practice. She is also highly regarded for her successful strategies of including parents as collaborative partners and as critical allies in the process of change. Stephanie Burns is a member of the law firm Keenan Bean, which is located in White Plains. She represents public school districts as general counsel in Westchester, Nassau, Suffolk, and Rockland counties. Ms. Burns handles student disciplinary proceedings, appeals to the Commissioner of Education, impartial special education hearings under the Individuals with Disabilities Education Act and New York education law. And finally, Stephanie Shabin is the legal director of Student Advocacy, Inc. Ms. Shabin is deeply committed to Student Advocacy's mission of providing legally based education advocacy services to students in Westchester and Putnam counties. In addition to her work at Student Advocacy, Stephanie serves on the Appellate Division, Second Department, Attorney for the Child Panel, representing children in family court proceedings, including Article 10, juvenile delinquency proceedings, PINs, and SIDGE cases. Following the three, each of our panelists will have an opportunity to do a presentation, and following their presentations, we will have a question and answer period. Participants may type questions into the chat box at any time during the presentations and during the Q&A. And we will answer as many of the questions as we have time for. We ask that you try to craft your questions as broadly as possible so that they're relevant for all panelists and to avoid lengthy fact patterns about individual children or students. So now I'm going to turn it over to our first panelist, Dr. Brady.
Good evening, everyone. I'm really pleased to be here, and I want to thank everyone for the invitation and for the opportunity to share some information from the more of the general education perspective regarding codes of conduct. So I'm going to try to do the one thing I never do well, which is share my screen. So if you'll just bear with me for a moment, and I'm going to see if you can see my screen. And I want to go to the layout here, I believe. Okay, can you see my screen? All right, thanks. So one of the things I thought we would do is just start with a general definition of codes of conduct. A pretty logical, it's a set of principles, expectations, rules that are given to students and parents to make sure that the expectations for behavior in your child's school are clearly communicated both to you and to your children. Codes of conduct can really help to clarify a school or school district's vision and mission and expectations. They also talk about how the adults in the organization will deal with behavior or enforce the code of conduct. And as you all know, our number one focus in schools is creating a climate that's safe and structured, a learning environment that promotes student learning and this goals of the school. So codes of conduct are really in place to protect everyone. And it's important that they strike a balance between positive and an emphasis on positive behaviors and what we would refer to as the punitive. As I mentioned before, all schools have a code of conduct, and probably the most critical thing to know as parents is that in the beginning of each school year, I believe you're being notified, or you should be notified by the district or by your child's school level principal or buildings. And you should receive the code of conduct before COVID. As many of you probably know, you would receive a hard copy, even if your school does not do a lot in hard copy. Parents were still receiving hard copies of the code of conduct and some kind of sign off where you would indicate as a parent that you have received it. And what you're also signing off on is that you have reviewed it, and more importantly, that you've reviewed it with your child. One of the things that I think is important for parents is no one knows your child like you do. And so if there are places in the code of conduct that you know for your child might be an area where you would want to focus, so whether that's the use of technology, or it could really be anything, that you make sure that you sort of point to and review those areas of in the code of conduct, so that your child is positioned to understand what their schools thinking and philosophy and their expectations around different areas. I think it's also important for all parents to understand and to point out to their children that there are certain things in schools that you'll find in the code of conduct that are really non-negotiables. They're serious. They are more serious than others. And I'm talking about violations of the Dignity for All Students Act, or DASA, as I'm sure you are familiar with that. DASA has significant legal implications for schools, for your children, for your families, and certainly the way that it impacts other children. So I certainly would encourage you to make sure that your children understand. We on the school side are continually trying to make sure that children understand what their responsibilities are around DASA. Other infractions that are serious, you'll often find them codified in Board of Education policy. And I'm talking about drug and alcohol violations, weapons violations that are also codified in state and sometimes federal laws. And there's much stricter enforcement of those in any school's code of conduct. I'm sure you hear about things like zero tolerance policies, although those have begun to fade away in some ways. But it's just important for children to know that, and for you to know that schools' hands are tied many times with these more serious violations. And it's just important to remember that. Violations of school district acceptable use policies, which are technology policies, are also taken very seriously. We have a lot of very techie children, especially through this past year. If they weren't techie before, they're techie now. And so violations of it are, it's just important for children to know that those are serious violations, whether those are social media driven and exist within the school sphere, or things as serious as tinkering with school databases and data management systems. Those are very serious. And it's just important for parents and students to know that. Board policies or DASA regulations are often found as appendices in the codes of conduct. So you'll see the actual Board of Education policies often right there in the code of conduct. And that's just something that also points you to the seriousness of those kinds of violations. Code of conduct, other than you receiving it in hard copy and then maybe putting it somewhere and never be able to find it again, if you're like me, you can usually find that on your school district website. And as I said, it should be easy to find. And they're not always easy to find. So it is something on the school side. We need to make sure that parents are able and students are able to find code of conduct easily. They're there to protect both students and staff. As I said earlier, you'll often find that discipline policies are progressive. They should be progressive in that they're designed to allow students to learn from their mistakes. So you'll often see that sometimes, depending on the violation, will start out as a warning, and maybe the second time it's a warning and a parent is contacted, and the third time there might be a detention. So that's what I mean by progressive. There's a behavior, there's an expectation that behavior changes when students are made aware. And if that behavior doesn't change, then the consequences will become more serious. One of the things that's interesting and is a challenge on the school side, just kind of important to know, is that often general education peers and parents have no understanding of IEPs. They have no understanding that students' disabilities may not map well to the code of conduct as they understand it. And so or as it is written. And that often causes what they perceive to be as fairness issues related to consequences. It's not unusual for us to have demands from parents to know what happened to other students in terms of consequences. They can be very relentless about insisting that they be made aware of what happened to the other students. Sometimes those students have IEPs. We never share the consequences of another student's discipline the same way that you certainly wouldn't expect the school to be sharing the consequences of your child's discipline with other parents. And we don't do that with general ed or special education parents. It really causes challenges for some parents in understanding that they just believe they have a right to know that. And they do not. And so on the school side, especially, again, sometimes when IEPs are in play, that can cause confusion among general education parents and students as well. One of the other things I thought I would talk about tonight, just briefly, because it is emerging a lot in schools, especially schools that are doing work around equity and racial equity and just equity in general. You'll hear about restorative practices and restorative justice, which was an older term. And basically, it's a discipline program that allows students to either resolve conflicts on their own. We used to refer to that as peer mediation back in the 90s. Some schools still have peer mediation programs, or allowing students to work in groups to resolve conflicts, mediate their grievances and their issues in small groups. The proponents of restorative practices will tell you that it helps in repairing harm and restoring relationships after peer-to-peer transgressions, and that it helps to promote a more positive school community. It does require an extensive amount of training for staff and for students, especially if you're talking about peer mediation programs. It's not appropriate for all infractions in the same way. And I spoke earlier about some of these more serious situations that we deal with in schools. And the research is inconclusive on restorative practices. It can be tricky for students with disabilities, depending on the level of their what their cognitive abilities as related to other students that are involved. And but you hear a lot about it. So that's why I'm mentioning it, so that you realize or are aware of what it is. Personally, I think it has a lot of value in certain situations, especially peer-to-peer, some of the peer-to-peer things that kids get into. Social media has fueled so many of these peer-to-peer or groups of peers, their interactions with each other. And if we ever get back to school where we're able to really sit with each other face to face, I believe that peer mediation can can really have value in the school community, but it does require training, and it does require an understanding of what it's for and when it is appropriate. Last, I'd just like to talk a little bit about equity issues and student discipline, because we talk about that a lot. PBIS is a somewhat popular program in schools. It's positive behavioral intervention and supports. It works as a tiered approach to supporting students and supporting the code of conduct and your school discipline program. It works pretty straightforward, that it teaches appropriate behavior to children. So children are taught explicitly how to respond in terms of appropriate behavior. It's a very early intervention before unwanted behaviors begin to escalate. It's very research-based. There's a lot of research on the effectiveness of PBIS. And it allows you to monitor student progress over time. It does have a tiered approach, and it has also been very effective in issues related to disproportionate discipline. And that often involves special education students, Black and Brown students, and there's lots of conversation, obviously, in our current universe about disproportionate discipline for different student groups. So that is what I thought I would share for this evening as a general kind of umbrella related to codes of conduct and school discipline policies. And so I'm certainly happy to take any questions that you might have for me.
So I think we're going to save the questions till after everyone has presented, but I want to thank you, Lisa, because that was just so helpful in understanding the purpose of codes of conduct and different types of discipline and conflict resolution. So thank you. Now I'm going to turn it over to Stephanie Burns, who represents many school districts in the area.
Good evening, and I want to thank everyone for attending and also for the honor of being part of this panel. I've worked many years with Stephanie Shadman across the table at various meetings and disciplinary proceedings, and it's really a pleasure to get to be able to know Dr. Brady. So at this point, I'm going to share my screen. Okay. All right, so I'm going to be starting just with a quick disclaimer that my presentation is not intended and does not constitute legal advice. And for any individual who has issues that are addressed during my presentation, you should certainly consult an attorney with any questions you may have. So I was asked to speak to some degree on the benefits from, at least from an attorney's perspective, of codes of conduct. And to me, a code of conduct sets forth the rights and responsibilities of all members of the school community to promote a safe, orderly, and civil school environment that is conducive to learning. And what it does for all members of that community, and particularly students and their parents or guardians, is it offers, if you review it, what the school district's expectations are for conduct on school grounds, at school functions. And please understand that when your child is participating in remote learning, that is a school function. Even though it's happening potentially in your home or in one of your relatives' homes or in a community environment. The code of conduct is still applicable. It also applies to conduct at school functions and towards members of the school community. It informs people what conduct is prohibited, what consequences may result from violations of the code of conduct, what procedures are followed for reporting and determining violations of the code of conduct, and what procedures are followed when disciplinary measures will be imposed for violations of the code of conduct. So you heard Dr. Brady mention the Dignity for All Students Act. It has some implications for districts' codes of conduct. So I thought I would start with just a brief overview of what the Dignity for All Students Act was intended to do. And it's intended to provide all public school students with an environment free from harassment, bullying, including cyberbullying, and discrimination, as well as to foster civility in public schools. It's intended to focus on the prevention of discriminatory behaviors, harassment, and bullying through the promotion of educational measures meant to positively impact school culture and climate. It requires all public school districts and boards of cooperative educational services, more commonly known as BOCES, to include provisions in their codes of conduct that prohibit harassment, bullying, and discrimination against students and or by school employees on school property or at school functions, as well as provisions for responding to such conduct when it occurs. So what rights are protected, what rights of students are protected in the codes of conduct? So all students are to be able to take part in all school district programs and activities on an equal basis, regardless of their race, color, national origin, ethnic group, religion, religious practice, gender identity or expression, sex, sexual orientation, weight, or disability. They're to be able to learn in an environment free from harassment and or bullying by school district personnel or other students on school property and school functions. To be free from discrimination based upon their actual or perceived race, color, national origin, ethnic group, religion, religious practice, gender identity or expression, sex, sexual orientation, weight, or disability by district personnel or other students on school property or at school functions. And they also have the right to present their version of the relevant events to school personnel authorized to impose a disciplinary penalty in connection with the imposition of such a penalty. So what can be the consequences for violating codes of conduct? They can take many forms and may include, but are not limited to, what you see on the screen before you. Oral warnings or correction, written warning, written notification to parents, detention, suspension from transportation, suspension from athletic participation or social extracurricular activities, suspension of other school privileges, in-school suspension, removal from classroom by a teacher, a short-term out-of-school suspension, which is a suspension of 5 days or less, or a long-term suspension out of school, which is considered a suspension that lasts more than 5 days. So the Dignity for All Students Act requires the development of measured, balanced, progressive, and age-appropriate responses to discrimination, harassment, and bullying of students by students and/or employees of the district. These responses should be included in the code of conduct and place the focus on discerning and correcting the reasons why discrimination, harassment, and bullying occur. The responses should also be designed to correct the problem behavior, prevent another occurrence of the behavior, and protect the target of the discrimination, harassment, or bullying. The New York State Education Department has recognized the following measures as appropriate responses to violations of the Dignity for All Students Act. And you can see the emphasis on preventative measures as well as teaching and learning appropriate behaviors. So they've recognized that violations of the Dignity for All Students Act may be remedied by peer support groups, the assignment of an adult mentor at school that the student checks in with at the beginning and end of the day, corrective instruction that re-emphasizes behavioral expectations or other relevant learning or service experience, behavioral assessments or evaluations, engagement of students in a reflective activity, such as writing an essay about the misbehavior and its impact on others, and how the student might handle the situation differently in the future, and or make amends to those who have been harmed. Supportive intervention and or mediation where constructive conflict resolution is modeled, behavior management plans or behavior contracts, and student counseling, parent conferences. So when a disciplinary penalty is going to be imposed, there's different procedures that are in place for students, and it depends on the nature of the discipline that's going to be imposed. So the most severe penalty, as we know, is a suspension out of school, whether that's a short-term suspension or a long-term suspension. And for students with disabilities, they have added protections, but at the base, they are entitled to the same rights and procedures as apply to non-disabled peers. So if we take an out-of-school suspension, that requires compliance with Education Law Section 3214, which means that the parents and the student have the right to be notified immediately by telephone if an out-of-school suspension is going to be imposed, and that's if the parent can be reached by telephone, as well as to receive written notice within 24 hours of proposed suspension that describes the conduct that caused the violation of the code of conduct, what the proposed period of the suspension is, and what your and your child's rights are to request an informal conference with the school principal. If the suspension will be for more than 5 days, in addition to these initial rights, any suspension that's going to exceed 5 days, the student is entitled to a hearing before the superintendent of schools or the superintendent of schools designated hearing officer. And you receive a second notice that tells you of the opportunity for this hearing, as well as your right to counsel and to question and present witnesses at such a hearing. In addition, your student, if they're of compulsory school age, which is ages 6 to the year in which your child turns 16, your child is entitled to alternative instruction during their suspension period. So for students with disabilities, before a disciplinary change in placement is implemented, a manifestation team is required to meet to review the relationship between the student's disability and the behavior that's subject to the disciplinary action to determine if the conduct is a manifestation of the student's disability. So what is a disciplinary change in placement? That occurs when a child is removed or suspended from their current educational placement for more than 10 consecutive days, or for less than 10 consecutive days if your child is subjected to a series of suspension or removals that constitute a pattern. And that is defined as because they culminate to more than 10 school days in the same school year, because the student's behavior is substantially similar to the student's behavior in previous incidents that resulted in the removals or suspensions, and because of any other factors such as the length of each suspension or removal, the total amount of time the student's been removed, and the proximity of the suspensions or removals to one another. A school district determines on a case-by-case basis whether a pattern of removals constitutes a change of placement. So generally speaking, a student with a disability cannot be suspended for more than 10 consecutive school days or 10 cumulative days in the same school year for conduct that is a manifestation of his or her disability without the consent of the student's parents. There are a few limited exceptions to that, which I will review in a few moments. So what is a manifestation team? The manifestation team must include a representative of the school district who is knowledgeable about the student, as well as knowledgeable about interpretation of information about child behavior, and the parent, and then relevant members of the Committee on Special Education as determined by the parent and the school district. So a manifestation team does not have to have all of the members of a typical Committee on Special Education, but it's not uncommon for a manifestation team to be very similar, have almost identical members to a Committee on Special Education. The manifestation team must review when they meet to consider whether a student's behavior is a manifestation of their disability. The team must review all relevant information in the student's file, including the student's individualized education program or IEP, any teacher observations, and any relevant information that's provided by the parents to determine if the conduct in question was caused by or had a direct and substantial relationship to the student's disability, or the conduct in question was the direct result of the school district's failure to implement the IEP. If either of these are true, then the team must find that the conduct was a manifestation of the student's disability. Manifestation determinations can be a complex process. They're determined on an individual case-by-case basis. They're very fact-specific. They're not determined solely by a student's disability classification. For example, a classification of emotionally disturbed does not automatically mean the conduct is a manifestation of the student's disability. It's not determined by the absence or presence of a particular behavioral goal. It must include an analysis of the student's program, as well as the student's physical, cognitive, developmental, mental, and emotional challenges. The student's behavior may be considered unrelated to their disability if the disability did not impair the student's understanding of the impact or the consequences of the behavior, and if the disability did not impair the ability of the child to control the behavior. If the manifestation team determines that a student's behavior is not a manifestation of the student's disability, the school may impose a suspension or removal, which would otherwise constitute a disciplinary change in placement. Or in other words, the student with a disability may be disciplined for the conduct to the same extent as a student without disabilities would be disciplined. If the conduct is determined to be a manifestation of the student's disability, there are a few requirements. That entitles the student to return to their school or program or placement immediately, unless there is a basis for considering whether an interim alternative educational setting is warranted. The CSE or CPSE, in the case of a preschool child, must conduct a functional behavioral assessment of the child unless one has already been conducted. And they must implement a behavior intervention plan for the child. Or if there is already a behavioral intervention plan that's been developed, they must review that plan and modify it as necessary to address the behavior. So what is an interim alternative educational setting, and when does it apply? A student with a disability can be removed from his or her educational placement for behavior that is determined to be a manifestation of their disability and placed into an interim alternative educational setting without their parents' consent for a maximum of 45 school days for behavior involving serious bodily injury, weapons, illegal drugs, or controlled substances. Now, it's important to understand that doesn't mean that every interim alternative educational setting is going to last for the maximum of 45 days. It just means that that's the longest it can be. The superintendent determines whether an interim alternative educational setting is warranted based on the student's conduct, but it is the CSE that determines what the interim alternative educational setting will actually be. So for purposes of determining whether an interim alternative educational setting is warranted, one of the bases is if the child's conduct caused serious bodily injury. And what does this mean? It means bodily injury which involves a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss or impairment of the function of a bodily member, organ, or mental faculty. Alternatively, an interim alternative educational setting can be warranted when a student with a disability carries or possesses a weapon to or at school, on school premises, or to or at a school function. In this instance, while a weapon is probably and should be defined in your district's code of conduct, for purposes of an interim alternative educational setting, weapon is also defined by federal law, and it excludes a pocket knife with a blade of less than 2.5 inches, but includes otherwise any weapon, device, instrument, material, or substance, animate or inanimate, that is used for, readily capable of causing death or serious bodily injury. And then illegal drugs or controlled substances are the final grounds by which a student could be placed in an interim alternative educational setting. And it's knowingly possesses or uses illegal drugs or sells or solicits the sale of a controlled substance while at school, on school premises, or at a school function. So the term controlled substance is as it is defined in certain schedules of the Controlled Substances Act, which is a federal act. And excluded from the term illegal drug are when a student is using a controlled substance legally and is pursuant to the supervision of a licensed healthcare provider. So one of the things you heard me mention earlier was if a student's conduct for which a discipline was proposed was found to be a manifestation of their disability, then the district has an obligation to do a functional behavioral assessment of that student if it hasn't done so previously. And what a functional behavioral assessment is it's the process for determining why a student engages in particular behaviors that impede their learning and how the student's behavior relates to the environment. A functional behavioral assessment should include the identification of the problem behavior, the definition of the behavior in concrete terms, the identification of the contextual factors that contribute to the behavior, and a formulation of a hypothesis regarding the general conditions under which a behavior usually occurs and probable consequences that serve to maintain it. The functional behavioral assessment should be based upon information obtained from direct observation of the student, information from the student themselves, the student's teachers, and related service providers, if there are any, a review of available data and information from the student's educational record and CSE file, and a review of other sources, including any relevant information provided by the student's parents. The functional behavioral assessment shall provide a baseline of the student's problem behaviors across activities, settings, people, and times of day with regard to frequency, how often the behavior occurs, duration, the length of time the behavior lasts, intensity, how severe the behavior is, latency, how long it takes for behavior to begin after a specific verbal demand or event has occurred. The functional behavioral assessment includes the information on why the student engages in behaviors that impede learning and how the student's behavior relates to the environment in sufficient detail to form the basis for a behavior intervention plan for the student that addresses antecedent behaviors, reinforcing consequences of the behaviors, recommendations for teaching alternative skills or behaviors, and assessment of student preferences for reinforcement. A behavioral intervention plan is a plan that is based on the results of the functional behavioral assessment and at minimum includes a description of the problem behavior, global and specific hypotheses as to why the problem behavior occurs, and intervention strategies that include positive behavioral supports and services to address the behavior. The behavioral intervention plan must include the baseline measure of the behavior, including frequency, duration, intensity, and latency of the targeted behaviors. It must include intervention strategies to be used to alter antecedent events, to prevent the occurrence of the behavior, to teach individual alternative and adaptive behaviors to the student, and provide consequences for the targeted inappropriate behaviors and alternative acceptable behaviors, and as well as a schedule to measure the effectiveness of the interventions. A behavioral intervention plan must be documented in the IEP, and such plan must be reviewed at least annually by the CSE or CPSC. The implementation of a student's behavioral intervention plan must include regular progress monitoring of the frequency, duration, and intensity of the behavior interventions, as well as the results of the progress monitoring must be documented and reported to the student's parents and to the CSE and CPSC. And that concludes my remarks.
Thank you so much, Stephanie. That was really helpful in starting to untangle all these complexities of how discipline applies to students with disabilities. Thank you.
You're very welcome.
And so our final presenter is now going, we had Stephanie, a lot of Stephanies. Stephanie Burns spoke from a school district perspective, although very objectively about the law. And Stephanie Chapman is also an attorney representing students, and we may get a little different flavor for some of these same issues. So I turn it over to you, Stephanie. Just make sure to unmute yourself.
Good evening, everybody. It's truly an honor to be on this panel with Stephanie Burns and with Lisa Brady. I've worked many years with Stephanie Burns on many cases where children have been suspended from school. I'm going to share my screen right now, and it's going to have a little bit of a different focus, my presentation. So let me try to just do that right this second. And there we go. Okay, so I'm the legal director at Student Advocacy. And just as a note of caution, nothing in this presentation should be construed as legal advice. And if you have specific questions about a specific child or matter in a school, you should really contact an education attorney before relying on any information contained herein. So what I am going to aim at teaching tonight is just a little bit about what codes of conduct are from the student's perspective, students' rights and responsibilities pursuant to the codes of conduct. And I'm going to target a little bit more on long-term suspensions. You heard Stephanie, exquisitely outline all the different types of suspensions and the things that students would be faced with if they violate the code of conduct. But I'm going to talk a little bit about what it's like to go to a hearing with a student with a disability or a typical student. And something that I'm particularly passionate about is stipulations. I'm going to talk about a little bit how important it is, and I really appreciated what Dr. Brady said about collaborating and working with the families, because that's our goal. Our goal is to go in and try to tease out what the problem is, what's the cause of the behavior, and how can we as a team, as a community, the school district, the teacher, the child, the parent, get together and figure out what would be best to solve this problem that the student might be facing. MDRs, which is manifestation determination reviews, and of course, tips for parents on what to do should your child be suspended. So, yes, codes of conduct apply. If it's a school event or a school function, and as Julie explained, before COVID, this presentation was originally crafted, but it still applies during COVID too. So it's equally as relevant. So some of the things that I will talk about in my presentation really have to do with general situations where a student might be suspended. But I just want everybody to know that it's happening and we are getting suspension cases at student advocacy. So here we go. Codes of conduct. So as was said by both Dr. Brady and Stephanie Burns, it should be reviewed every year with your student just to understand what the expectations is. It's a good starting point to have these conversations. And when we talk about suspensions, it's always been student advocacy's position that out-of-school suspensions don't teach children how to go to school and don't help them in school. And this might look like what some parents' houses look like during COVID, but this was intended when all the children were sitting in school and that child was told not to go to school because they were suspended. So when I'm talking now is more about long-term suspensions, and official suspensions triggers procedural safeguards for students. So very often parents or very well-meaning teachers or professionals will say, well, we want the kid to have a mental health day, keep them home, or pick your kid up, he can't manage today, or the constant pick your kid up early. And it sounds kind of harsh, but we would prefer at student advocacy for the child to receive an official suspension, because as Stephanie explained in her presentation about MDRs for students with disabilities, it will start the clock running towards whether or not an MDR should be held. It will also highlight the need for interaction and interception by higher level people, whether it be the principal or the school psychologist. If it's just handled quietly, the procedural protections put in by the law will not be afforded to the student because they're not officially suspended. When you're officially suspended, you need to have a letter. It should be an informal conference with the principal. And if you get to the hearing component, there could be presentation of witnesses and right to bring an attorney of your choosing, and possibly an MDR. So, who can suspend? Sometimes suspensions can be done by the Board of Education, the trustees, or the superintendent, or the principal, either a principal suspension or a superintendent suspension. Guidance counselors, teachers, security guards, assistant principals under law don't have the authority to suspend. So what is a long-term suspension? It's when they're seeking a student be out of school for more than 5 days. Now, this would apply to a typical student or a student with a disability. Whoops, too fast. And what are you suspended from? So in COVID world, there might not be a kid driving on school or a concert or a game. And I hope we get to the point where we have that again. But you're suspended from all school events and functions. So if school A is playing school B in a basketball game, even if your student is a student of school A, they may not attend the school B function. It's a school function. You're not permitted to go. And very often parents and students don't really know that. So I feel like that's an important piece of information. When you're suspended, you may not go. So if we get to the point where we're going to have a hearing, so they're seeking a long-term out-of-school suspension, people don't really understand what that looks like. And I think it goes to a very good point made by Dr. Brady about parents feel they have a right to know what the discipline is of this kid and that this is and that. They don't have that right. It's a closed meeting with that student, and it's a very simple question. Did that student commit the violation of the code of conduct that the student is charged with? It's not to discuss whether they like the school or the teacher or the classroom. And it's not to bring up all of the history of that student or that parent's relationship with the school. It's just that simple question. And it is a technical legal hearing, and parents very often, if they go unrepresented, don't understand what that hearing could look like. Now, as I said earlier, we always hope that it doesn't get to the hearing stage. We always hope that we can work it out in some kind of amicable or collaborative way with the school personnel and the school attorneys, because we feel it's best for everybody. But if you get to the point where there's a hearing, it's a very short question. So I don't think that parents, unless you've had that experience, don't realize there's no jury. It doesn't look like that. There's no stenographer. I mean, it has to be recorded, but it doesn't look like what it looks like on TV. And I really like to impress that upon parents and students, because it's important that they understand that, so that they don't ask for things about what happened to another kid, or start saying things about something that happened 5 years ago in another school building, because it's not appropriate. Okay, so this is the nuts and the bolts of the hearings. Hearings in New York are bifurcated. There's a guilty or innocent, the fact-finding phase, and then there's a penalty phase. There are two phases. So first, they want to determine whether or not the student committed the offense that they were supposed to have committed. Now, this is where the important layer of disability rights comes in. So who is entitled to this manifestation determination, and how does that happen? So you heard Stephanie Burns speak very eloquently about all the different procedural requirements and who makes up the team, and it was beautifully done. And I agree with that. But a student, this is an entitlement of a student, and it is a very, as you heard, technical meeting. So again, I urge parents not to go unrepresented to hearings and not to go unrepresented to meetings. So if you're a student with a disability and you're facing a long-term suspension, you would be entitled to a manifestation determination review, known as an MDR, if you're a student with a 504 plan, a student with an IEP, and also a student who is presumed to be disabled. And these are all very explicitly drawn out in the sections of the regulations. And people call our offices all the time and say, my kid has an IEP, school can't suspend. And I have to be the bearer of the bad news, because whether or not you have an IEP, you can absolutely be suspended. You're afforded this protection, and if you win an MDR, you can't be punished for the behavior. But it doesn't mean that you can't be suspended. You sure can. So that's a very big misperception that I'd like to quash for parents, because I don't want you to think that because your kid has an IEP, schools can't suspend them, because they have every legal right to do that. But what they must do is the manifestation. And there's a specific team that's brought together. If the child is found guilty of the offense, instead of jumping right to the penalty phase, there must be a meeting of what's called the manifestation team to determine whether the conduct was caused by or had a direct and substantial relationship to the student's disability. So what that means is we're trying to level the playing field. We're not trying to suspend children because of their disability. Or there's one other circumstance, is the conduct in question was the direct result of a school district's failure to implement the IEP. Not, oh, my kid missed 15 minutes of speech and language, but if there was a real direct result, if the behavior was a direct result of this kid not getting his IEP services, then a manifestation would be found. Now, if a disabled student is found guilty and prevails on the manifestation meeting, the student must be returned to school immediately, with some limited exceptions, which was explained in the IAES. But an FBA must be conducted or updated, and a BIP must be developed or amended. So that is also all laid out in the regulations. But this is the right of students who struggle with disabilities, because this is what they're entitled to, so that they're not it's not punitive because they have a disability. If you lose on the first one and the second one, you go right to the penalty phase, just like any other student. And that's where the only question is what is going to be the penalty. And many documents can be reviewed: the academic record, prior disciplinary history, attendance record, severity of the incident, character of the student. So if you take one thing away as a parent from this, if your child is facing a long-term out-of-school suspension, I really hope that they have representation so that you can be guided to properly navigate this administrative proceeding that your child is faced with. And hopefully, if you come to a place like student advocacy, you're going to have people who really want to work together with the school district to get either to a CSE meeting or get the kid evaluated if he or she needs it, so that we can work it out so everybody can go to school to learn. Alternative instruction is if you're out of school and you're of compulsory school age, you're absolutely entitled to that. And what I really want to leave you with is codes of conduct, kids in school. Our goal is a collaboration among students with disabilities, parents, and schools to foster compliance with the codes of conduct. We don't want to foster behavior that's in violation of it, and also to foster compliance with the procedures of state and federal laws and regulations to ensure that all children are ready to learn and their rights to receive a free and appropriate public education are always protected. So I thank you. If you have any questions, I'd be happy to answer them. Thank you for your time.
Stephanie, thank you so much. And I always appreciate that collaborative approach that you approach your all situations. And it's really helpful to get greater understanding that students with disabilities indeed can receive discipline, can be disciplined and suspended, but families do need to be mindful of those added layers of protection. So that was really helpful. And it's great to hear it from both your perspective and a school district perspective. So thank you to all three presenters. And I want to see if we have some questions in the chat. I do see there was a question now. Alyssa, I think that only the panelists are able to see the chat. And there is a question that I'll read aloud. Does the 10-day suspension count if it's an in-school suspension? So does it count towards those 10 days as constituting a change in placement? So what the person who asked the question was getting at, some children are given in-school suspensions for a really substantial part of the day. So would 10 of those in-school suspensions add up to a change in placement, or how much of the day would a child need to have an in-school suspension? So anyone who wants to, any of the panelists any and all who want to answer that.
Sure. To me, whenever a student with a disability is brought to my attention as being a subject of possible discipline, I always ask for what are the days of out-of-school suspension and in-school suspension, because if you listen to the definition, it does talk about removal from the student's program. So it's not limited to actual suspensions. If you think of suspensions as being out-of-school suspensions, it's when the student is removed from its program. So to me, I would look at it on a period by period basis or a half-day basis. So if the student was removed, they attend an 8-period day, or they're a younger student who is attending 6 hours of instruction and was in school suspended for 3 hours or for 4 periods, that's half a day to me towards the 10-day. And if they exceed that, you're probably going to round up, because remember, this is what triggers a manifestation team meeting. It doesn't mean if your child is a student with disabilities, they can be suspended out of school for 2 days or 3 days or 5 days without having to have a manifestation team meeting or determination. They're not necessarily protected from that, but if those suspensions in school or out of school are culminating to 10 days, then it needs to be a manifestation team meeting. And whenever a long-term suspension is proposed, like Stephanie discussed, you do have a manifestation team meeting in between, because presumably the student's been out of school by the principal for 5 days and now is looking for the superintendent to extend that period. So because there's the potentiality for it to extend beyond 10 days, the regulations require us to have a manifestation team meeting between the penalty and the guilt and penalty phases of a disciplinary hearing. I'm sorry, I droned on, but the short of it is in-school suspensions do count towards disciplinary removals.
So
So
I
that's
would
their
just,
day period.
I would just like to add, it's very helpful because I think people don't understand that, Stephanie. So I think that's really great for parents to know that. But if you look at it from this way, if the kid starts to get suspended a lot, if it's 8 days, I mean, we could be a stickler about the amount of periods and the time. It's something's going on. It should trigger the team to meet, to have a conversation about what's happening and what the child needs. Is he need more or she need more services? Is the program correct? Is the IEP not being implemented? And to me, that's the greater question is let's get all the people at the table, the parent, maybe the kid's outside therapist, whomever, to try to figure out how to help the kids stay in school. And I think that's really the whole protective layer. We look at it as like, oh, we have a right to this. And yes, you do have a right to it. But there's a real deeper meaning to it from my perspective.
I don't disagree with that. And certainly anytime a parent has concerns, they can always request a program review. It
Absolutely.
doesn't have to be done as a manifestation,
Mhm.
determination or team meeting. What I would say is it's not just also keeping students in school, but in school in their programs is what the manifestation determination is aimed at. So that's why the in-school suspensions and out-of-school suspensions both count towards that 10-day period, if you will, or a 10-day threshold.
That's a good point. Lisa, if you don't have anything to add, I'll go on to the next question, or if you'd like to add, that's fine too.
I was just going to say that anytime children or students are not in their classes with their teachers and learning, they are out of the instructional program, right? So whether they're sitting in the library or whether they're sitting in wherever, they are not in their classes learning. And so that is, I believe we need to intervene early. That's why I'm a proponent of PBIS and other strategies so that we can talk with children and meet with kids to keep them in their classes with their teachers. So I just wanted to say that from not a legal perspective, from a school, from the school administrative school perspective, and as an advocate for children and families, we want children to be where they're supposed to be in their classes.
Absolutely. Next question is, can you talk about an example where a manifestation determination review could result in a finding that the behavior was a manifestation of the disability due to the school's failure to adequately implement or review a behavior intervention plan, the BIP?
Well, I don't quite follow that, but if a student has a behavior intervention plan on their IEP, so they already have one, and we've come to a manifestation team meeting, if that behavior intervention plan has not been followed, then that could lead to a determination that the conduct is a manifestation of the student's disability. Another example I can provide possibly is, say a student has counseling on their IEP, right? Once a week or twice a week, whatever it is, for 30 minutes. And for whatever reason, they have not been getting those counseling sessions. That can be another thing that can lead, depending on if the counseling, you look at the goals, what was the goals of the counseling, and then you look at what the behavior was that you're talking about. And if there's a linkage, right? If it's a student who has difficulty controlling their emotions, and their goals with this counseling were to work on recognizing their triggers or recognizing other things, that's something that if they, and I'm not talking about one missed counseling session, but if they have not been getting on a regular basis their counseling session, and I also don't mean if the student has refused, like the counselor has made that time available and had that student and the student has refused to come or refused to participate, that's a different story. But if it hasn't been provided, hasn't been offered, the student didn't have that opportunity, that can be a time where a manifestation is going to be caused by the fact that the IEP was not implemented. Another example that I have not actually experienced, but I saw in some materials where they were talking about, say a student has the ability to see a counselor, right, on an as-needed basis, and the student approaches a teacher and asks to go see the counselor and is denied that opportunity and then engages in behaviors. That could also be a time where it's not their program or necessarily their related service, but it's one of their accommodations and they were denied their accommodation. And that was directly linked to the cause of the behavior. That could be another instance where you might see a manifestation be caused by a failure to implement the IEP.
If no one else thank you. That was really helpful to get an understanding of how failure to implement an IEP can be linked to an MDR. So the next question is, can parents request that a superintendent's hearing in progress reconvene on a subsequent day to allow for a longer manifestation hearing or allow parents to obtain representation or particular documents for consideration? So can we interrupt the superintendent's hearing and reconvene on another day?
So,
Go ahead.
in my experience, it's fact determinative, but usually a hearing officer is going to be willing to grant the adjournment and allow a parent, particularly if the parent is seeking representation. The one thing that's comes up as a wrinkle to that, though, is if you're seeking that adjournment as a parent, your child is going to remain out of school until that hearing continues and is concluded. They're not going to be, if they were suspended by the principal for 5 days and they're on day 4 and you're in the hearing and now you're going to reschedule the hearing for 2 or 3 days from now, they're not going to come back into school in the interim. They're going to remain out of school getting their alternative instruction, presuming that they're compulsory school age, or even a lot of school districts provide alternative instruction even to students who are beyond compulsory school age, because nobody wants them to be falling behind. I can't say every school does, but it's very frequent that students are not cut off from alternative instruction just because they're 17.
So it has always been student advocacy's position that it's better to be prepared for the hearing. And very often, sometimes you have to delay a hearing because you don't have the records or because you haven't spoken to the child's therapist or whatever research or investigation you need to do to properly prep your case. Or you haven't spoken to the child, your client, or whatever. So I know it seems like very painful to say, well, my kid's going to be out of school a day or two longer, or maybe even a week or two longer. But when they're facing a year out of school, it seems better to be prepared. And that's always been student advocacy's position, is better to prepare. And Julie, can I just jump in, because I got a message in my chat about someone asked a question about what is a stipulation. So it just would take a second to explain that. So when a school district and the parent decides not to go forward with the hearing, and there's an agreement, and it's typically done when there's attorneys involved, so because it's got to be crafted and it's got to be appropriate, you come up with an agreement. It's a settlement kind of situation, and you have a lot more flexibility both from the school district's perspective as well as from the student's perspective to negotiate. So the school district might say, well, you're going to be suspended, but if you do A, B, and C, you might be able to return on such and such a date. Or the parent might say, waive the manifestation determination and be returned to school earlier. There's so many nuanced, different ways to write a stipulation, and you can really write anything because it's an agreement between the parties. It's a contract as long as the parties agree. So we find it very advantageous not to put the child in a situation of going to a hearing, waste the teacher's time, who might have to testify for so many reasons. It's so much better and it's so much more amicable. Even though sometimes the lawyers have to kind of work out that stipulation, it's usually to the advantage of everybody to come to an agreement, because after all, that's the child's school and that's the child's teacher or the child's principal or whatever. So I always am in favor of, if it's doable, if it's possible,
to enter into a stipulation of settlement prior to the hearing, although it could potentially happen after a hearing in some circumstances.
Yeah.
Not ideal.
Yeah, it could happen before penalty. It usually happens before the hearing, but I just want to add on to what Stephanie Shadman said, and that's the stipulation. In my experience, there are some districts that also enter into them with the parents. They do it directly between the principal and the parent will negotiate it, and then I might get the call to write it up for them, but they've negotiated it. So it's not always developed between two attorneys. But sometimes the reason that a stipulation comes about is a lot of times a school district wants a different kind of remedy, right? Maybe they want counseling for the student, or maybe they think the student would benefit from some counseling, and they would rather see
Yes.
that than see the student out of school. Because when a school district goes to a hearing, the only thing that the superintendent can do at the end of that hearing under 3214 is suspend the student additional days out of school. Like, that's the only consequence, I should say, that this superintendent can impose. But maybe they want to have the student do community service instead, or they want to have the student, maybe in the school or in the community do community service instead as a consequence for their actions. The superintendent couldn't decide at the end of the hearing, I'm going to, sentence you to 10 hours of community service. They don't have that under the education law. They're constrained to only be able to do additional days out of school. So stipulation of settlement can be a way to craft a different type of consequence or different supports for a student if they feel. I often have school districts who want to have a student receive some counseling services, and that they use that stipulation to get the parents and the child to agree, whether that's out of school counseling with a private therapist or even sometimes in school.
Wow.
Did you want to add something, Lisa?
No, but I can't express how strongly I feel about what Stephanie just said, and that there is often and always wanting for students to get the help and the support that they need. And sometimes that's being resisted for all kinds of reasons by the parent and the student, especially when you're with high school students where the students themselves have very strong feelings about whether they want to see a counselor, whether they're willing to get the kind of help that the adults around them really believe that they need. And so stipulations are a way of trying to make sure that the outcome is not just more days out of school, but that students are getting supports and the help that they need. I had a message in the chat too. I just wanted, because I think it's a good question, and it's just off a little bit on a different topic about whether school districts being required to review their code of conduct, and do I think that all school districts actually do that? And so I just wanted to respond that I hope they do. I certainly don't know for sure if they do. But one way that you might know whether your school district is doing that or not is that when any substantive changes are made to the code of conduct, a public hearing has to occur on the code of conduct. So often Board of Education policies, even that the board, hopefully your board is doing policy work over the year, but Board of Education policies change, which can have implications for code of conduct. So what we do is we monitor that over the year. In the spring, we make all of those changes. And then in the summer, if the changes are substantive, we have a public hearing on the code of conduct. So if your school district never has a public hearing on the code of conduct, and you know that you're aware that there have been changes in laws, that's one way of maybe knowing whether your district is reviewing the code of conduct annually. And but it is required, and I certainly hope that most districts do it.
So on that exact point, what I learned from both Dr. Brady and Stephanie Burns the other day when we were preparing for this is that some districts actually did change their code of conduct to include situations involving COVID. And I thought that was a very interesting thing, because everything's been happening so fast. I don't think anybody's even had a chance to take a look at some of those things. So I thought that was quite extraordinary that school districts took the time to do that. And I would be very curious to take a look at them personally, because I'm personally interested in it. But I think that's important so school districts are paying attention to what's happening in the world and trying to include that in the code of conduct, because it's the responsibilities of the student, but it's also the rights of the student. So I think that's terrific.
And not to be negative, but I would say most school districts in the last few years have, look, they're required to do it every year, and I like to believe that school districts do it every year. But certainly in the last couple of years, I'm confident school districts have, because of vaping, quite frankly, created a big issue for a lot of school districts. They needed to address that better in their codes of conduct, because parents were challenging suspensions and other disciplinary measures by saying it wasn't a cigarette or it wasn't smoking. And that's been a huge issue that I've seen in schools. I don't mean to be negative. I just mean, and I'm not saying that's the only way schools are combating vaping, but that was something that caused them to have to review their codes of conduct, right? To how do we address vaping in our code of conduct?
And apropos of sort of how current events impact discipline, a couple of the participants have asked, outside of suspensions, what conduct violations are schools seeing during COVID?
So I would say that one of the things that we're dealing with, so first of all, school behavior management issues are down during COVID, right? Because obviously the kids are not in front of us. So the things that we're dealing with, at least in my purview, students who are, like, if I was to put my name up, okay, so let's say I turn off my camera, I'm in my Google Meet, I turn off my camera, and the teacher has no idea whether I'm eating my breakfast, playing a video game, right, on the other, on the other side of the screen. And so teachers having a hard time enforcing, with some students actually attending the Google Meets. And it's hard for them to know. They call the student's name. I say, Julie, are you there? Julie, nobody's answering me, right? And so we've encouraged teachers to reach out directly to parents and to try to make parents aware, because parents may not even know that their students are not fully attending. But most of the behaviors are really related to attending and actually being there. And of course, in elementary school, we still do have some of the behaviors of, my dog is in the screen, and, these things that we smile and chuckle about sometimes, but for the teacher that's actually trying to run the class, it gets, it can get problematic. But those are the things mostly that we're dealing with in the COVID world. And obviously not suspensions.
Yeah, I've seen some acceptable use policy type violations potentially, right? Like, and also this, obviously the social media that students engage in still persists, obviously, at this time, and can cause some disciplinary consequences. But I have to say, I'm not saying it's not happening, but I haven't had very many student suspensions come across my desk since COVID came.
One participant asked, given the remote learning, if a student is being cyberbullied, is that an issue for the school to address?
Certainly depends on, how it's impacting them, but if it's preventing them from engaging in instruction, then yes, absolutely. It's an issue that school districts are tasked through the Dignity for All Students Act to address. There's many ways parents can seek to address cyberbullying of that nature. One, they can contact their school districts. They can also contact their local police departments and other community groups. But yes, that would be bullying and harassment and discrimination don't necessarily go away because we're in a remote learning environment.
Did anyone else want to comment?
I'll just say that and those are always very complicated, right? Whether we're in school or not in school, because some of that behavior is occurring outside of school, but the nexus to the school is a student who doesn't want to attend, whether that's attend a Google Meet or whether to actually attend school physically because of other students who might be in that class, whether that's virtual or whether it's not virtual. And those are always very complicated. But you refreshed my memory, Stephanie, about a situation that we had last year that was very much in that wheelhouse.
And another participant asks, even if a student has received appropriate IEP services, i.e. counseling, and a BIP was implemented accordingly, that does not mean the conduct offense was not still a manifestation of the student's disability, i.e. intermittent explosive disorder, correct?
Right, there's two. Oh, sorry. I didn't mean to cut you off. Correct. There's two things. That's a separate basis for finding a manifestation that there was non-compliance with the IEP. But the main, I shouldn't say the main, because they're both equal questions that are asked in a manifestation determination. But the other question, and yes to either one. You don't need yes to both. You need yes to either one. Can cause. So you're always still looking at whether the conduct had a substantial relationship to the student's disability.
And I would certainly agree that the first question, the relationship to the disability, is far more common from my experience.
Yes.
The latter one, but the latter one's kind of easier to talk about because it's very hard to establish the direct and substantial relationship. So you really need to have to dig into like the psychological or the history of that child in school and what those patterns of behaviors have been like historically and that child's experience. And it's very fact specific and individualized because there again, a parent will say, well, my kid, got back into school after he went to this meeting. And he went, and that probably did happen because it was found it was a manifestation of his disability, so there's all that, the nomenclature and all those things that parents might hear and not understand all of the nuances of the law and the protection level. So that's all that happens very, very often. The other thing that Stephanie Burns brought up is just because a kid has an ED classification doesn't necessarily equal a manifestation. And that is definitely true. It has to be the behavior and it has to be the direct and substantial. But the converse of that, which for years we've found, I haven't seen it as much recently, but in certain districts, if the kid was classified LD, no way, no manifestation. And that's not true either. The classification has no impact on whether or not you can answer those questions yes. So I think that's something very important for parents to understand, like, oh, it's not a waste of your time. And it's a very important meeting. It's not a meeting that you should, years ago we would say, well, we want you to be there physically present. It's an important meeting. I mean, now nobody's physically present at the meetings, but manifestation determinations is a very important meeting and it's a technical meeting. So I always encourage parents to go and not do it while they're, at work and, to really pay attention to what's going on.
And I think this will probably have to be our last question. Does the alternative instruction include the components of the IEP pending the determination of the MDR? So if a student, I think it means if the student is suspended, does the alternative instruction include components of the IEP while the MDR is taking place?
I'm not really sure what that's trying to ask, but
You see the question?
When a student is suspended out of school, regardless of whether or not there's been a manifestation determination yet or not, if they're suspended out of school, they have the right to alternative instruction. It may take a district a day or two to get it in place, and they have to make substantial efforts to put it into place. If they're trying to ask if they get their related services, yes, the answer to that is yes. For students who have a disability, they don't get them more frequently, but they're entitled to them at the frequency that they would have had them at They were not suspended. I hope I'm
I think that the questioner clarified that the question related to when we were discussing postponing the meeting. So does the student continue to get the alternative instruction if a meeting is postponed? I think that's the question.
Okay, so yes, once the school has the alternative instruction in place, it's going to continue until the student returns to school.
Okay. Can we do one more quick one?
Yeah.
This is a quick one. If it is found that the behavior is not a manifestation of a child's disability, can the parent appeal the decision, and if so, to whom?
Yes, they can seek an expedited impartial hearing. That's how you do it.
Okay. Okay, I think it's pretty much 8 o'clock on the nose. I can't thank our panelists enough. You just have collectively and individually so much wisdom, and you shed so much light on this important topic. And I know it's a source of anxiety and stress for a lot of people. And I think that being empowered with all of this information and being encouraged to read codes of conduct at the outset of a school year is really great for families and for professionals. So thank you all.
I would just like to give a shout out to you, Julie, and Bess, and everybody else who's, and all the exec committee who's always behind all this, who spends hours thinking of these and holding meetings and getting us all ready. So thank you for all your hard work and for the community, for our special ed community.
Thank you
Yes.
so much for those thoughts. I really appreciate it, Stephanie.
I echo those. You're a very organized organization. It's a pleasure to be part of your panels.
Well, you better be careful because that means you're going to be invited back.
Thank you also. It was really a pleasure to be here and very, very interesting to listen to my fellow panelists and questions from parents. So thanks again for including me.
Thank you all for taking the time out of your busy schedules. And thank you to all the participants for attending. We really appreciate it. We look forward to seeing everyone soon post-COVID.